Welcome, everyone. I'm Betsy Russell, and I am a newspaper reporter. I'm also the president and co-founder of Idahoans for Openness in Government, or IDOG, which is our state coalition for openness in government. More than 40 states have coalitions like ours. We're funded by grants and are a 501c3 nonprofit. Since 2004, we have partnered with Idaho Attorney General Lawrence Wasden to train state and local government officials, members of the news media, and the public about our state's two key open government laws, the Idaho Open Meeting Law and the Idaho Public Records Act. At IDOG, we believe that we all benefit when the public, the media, and government officials are fully aware of the public's rights to access government information and observe the conduct of the public's business. It's vital to me in my work as a reporter. It's vital to all of us so that we can have open government supervised by an informed and engaged citizenry. We have taken our show on the road and held 50 seminars like this across the state on this topic, all in person, until COVID got in the way last year. So we improvised, and more than 500 people participated in our virtual session on open meetings in a pandemic last January. Today, we'll do a virtual version of our full seminar, both laws. We're glad that so many of you have been able to join us. Your questions can be submitted to questions@ag.idaho.gov, and Scott Graff of the Attorney General's office will pose them for you. He advises that a question about just a specific situation that you've experienced might be better handled offline, but something that's a little more generally applicable will be more likely to get asked today. The first portion of the program today will focus on the Idaho Open Meeting Law, including solid information and answers to your questions from Chief Deputy Attorney General Brian Kane. Then we'll have a 5-minute break, and the final portion will focus on the Idaho Public Records Act, again, including the real scoop on this law and answers to your questions from Brian Kane. And it's now my privilege to turn it over to our Idaho Attorney General, Lawrence Wasden.
Thank you, Betsy, and a special thank you to you for you've been to every one of those 50 presentations. That's a lot of travel time, a lot of preparation time. But thank you to all of you for being here. I also would like to thank Idahoans for Openness in Government and the Idaho Press Club, because they've made a lot of efforts to support our work here. And this is our first virtual seminar in dealing with both public records and open meetings. So if we make a few guffaws or faults, please forgive us. We're working hard to try and make this meet your needs. But since we began doing these in about 2004, as Betsy mentioned, we've done more than 4 dozen of these, and we in part have received an IDOG grant. And one of my goals as Attorney General is to improve the communication between the Office of the Attorney General and the public. And then as a consequence, I travel across the state to visit local government, to talk to citizens and service clubs, and to make myself available to news organizations throughout the state. Years ago, on one of those trips to Idaho Falls, the then managing editor of the Post-Register suggested that we needed to enlarge our training concerning public records and open meetings, and suggested the basis of this program, and worked hard on it for a long time. I really felt like that was a great idea to bring together local government, the media, and the public at large to learn about these laws. It serves 3 purposes for us to have a common understanding. First of all, to provide timely access to public information. Second, to protect information that the law requires to be protected. For example, records of active law enforcement investigations. And 3, to reduce the conflict over access to government information. And my office has provided open meeting and public records training to local governments for many years. I'm happy to have members of the media and the public joining us in this effort. In fact, we have some manuals, both online and physical copies, that you are welcome to have. The red one's the Idaho Public Records Manual that we're going to talk about a little later. The blue one is the Ethics in Government Manual. We're not going to talk about that today, but something very worthwhile to look at. And the green one's the Ethics in Government, and the blue one is the Idaho Open Meeting Law. I'm colorblind. I'm not really, but I was at that moment. So Oftentimes what happens is people will call us when there's a dispute about open meetings or public records, and government officials will call Brian Kane, my chief deputy, and oftentimes folks from the media will call Scott Graff, who's my public information officer. Over time, we found out that about half the time, one of them was right, which meant about half the time the other one was wrong. And that just flips back and forth between who's right and who's wrong. Now, batting 500 is a great thing if you're in the World Series in October, but that's not a very good thing if what we're trying to do is work on public records. So our hope for today is that at the conclusion of today's session, that we have a batting average greater than 500, that people recognize there is a sheet of music, even if they don't always sing in tune. Again, I want to thank Betsy for taking the time and making the commitment to be here, as well as all of you who've taken out time from your busy schedules. The fact that you are here demonstrates that your respective local government officials are committed to open government. Those of you in the media, you know how important this is to you. And those of you who are in the public, thank you for being with us. Betsy, we're back to you.
That's right, unmute. Okay, got it. So at our in-person seminars, we do some play acting, and we have people in the audience take on roles in skits that help illustrate how our laws should and shouldn't work, often with some merriment and some bad examples of things that we really shouldn't do in order to learn what we should do. Well, that is a lot of fun and a great way to learn about the law. Today, we won't be able to have the audience do the acting, but we do have a couple of those skits performed by actors with the Idaho Shakespeare Festival. So here is an open meeting law skit entitled When Secrecy is Permitted, featuring reporter Ernest McScoop and Trudy, the city clerk.
In certain circumstances, public officials may meet in private sessions, but these exceptions are rare and clearly spelled out in Idaho statutes. Let's watch a scene in which the open meeting law permits secrecy. Meet Ernest McScoop, an eager news reporter for the Daily Splash. He's on his way to the city council chambers until he's stopped by the city clerk.
Ernest McScoop, what do you think you're doing?
Oh, hi, Trudy. I'm just going in to watch the city council meeting.
I'm afraid not, McScoop.
Hey, I know you're the city clerk and all, but you can't stop a trusted reporter, or anyone else for that matter, from sitting in on official city business.
I'm afraid I can if the meeting's in executive session.
But today they're talking about Lyle Brody's lawsuit against the city. That's juicy stuff. Do I have to mention that there are open meeting laws?
Sorry, McScoop. The open meeting law allows executive sessions to consider and advise the city attorney in pending litigation.
Well, that doesn't seem right. Aren't they spending the public's money in there? The people have a right to know how they're spending it and how much they're spending.
Oh, yes, you are truly the taxpayer's champion, McScoop. But what would happen if your paper printed that the city attorney said that we should settle for $50,000?
$50,000?
That's hypothetical.
Shoot.
You print that, and Lyle could read that the city is ready to pay $25,000 more than he would have eagerly grabbed. You just cost the taxpayers quite a bit of their money.
Okay, I stand corrected. Hey, can I buy you a cup of coffee with all that tax money I just saved myself? There is no foul on the play. The open meeting law allows executive sessions. However, there are strict limits on the circumstances under which an executive session is permissible. This goes for all public agencies. Let's see the exceptions on the big board. To consider hiring, to consider personnel evaluation, dismissal, or discipline, to deliberate concerning labor negotiations or purchases of real property, to consider records that are exempt from disclosure, to consider preliminary negotiations in matter of trade or commerce in which you are competing with governing bodies in other states or countries, to communicate with legal counsel about matters regarding pending litigation or controversies not yet being litigated but imminently likely to be litigated, to engage in communication with the agency's risk manager or insurance provider to discuss the adjustment of a pending claim or prevention of a claim imminently likely to be filed by the Commissioner of Pardons and Parole, the Sexual Offender Classification Board, and the Custody Review Board of the Idaho Department of Juvenile Corrections as provided by law. Any other discussion in executive session is prohibited. If you don't have a referee handy in your office, open meeting regulations are spelled out right here in the Attorney General's Idaho Open Meeting Law Manual. And you can find that on the Open Idaho website at idahoptv.org/OpenIdaho. It's the rule book for fair play in open government.
There we are. Now I think I've got some sound. The law provides that exceptions to the general policy of an open meeting shall be narrowly construed. That means that the exceptions for having a public or an executive session are to be confined by the court. That same section 74-206 subsection 2 makes it a violation of the open meeting law to change the subject within the executive session to one not identified within the motion to enter the executive session, or to any topic for which an executive session is not provided. I can tell you from personal experience, on a number of occasions, I've had to help executive bodies stop subject drift from one subject that is permitted in an executive session to a subject that is not permitted in an executive session. And that's something we all have to be vigilant about. There are two agencies that have additional authorization for closed meetings, and that's the Parole Commission and the Custody Review Board of the Idaho Department of Juvenile Corrections. But these are very limited exceptions, and their authorization is spelled out in statute. Betsy or Brian.
We're going to turn it over to Brian now. I want to apologize for that pause earlier. I wasn't sure if the skit was running or not. So I just sat here, but this time I know if it's not running, I'll keep talking. We're now ready for Brian Kane to fill us in on all about this law.
Thank you. Now we're going to go through the open meetings law. And I just need to transition here to share my screen. So the open meetings law, as you know, we've got our manual and the open meetings law. I think the best way to think of the open meetings law is it's your ticket to the show of government. And I like to use the term show because what the Idaho open meeting law does is it guarantees your right as a citizen to observe your government in action. It isn't a guarantee to participate. And one of the most common questions that we get within our office is, I went to the open meeting, they didn't let me talk. And the answer is, that's okay. Now, when government opens up and has like an open forum, or maybe they're operating under a different statute where there's a hearing requirement, then yes, you would have the opportunity to speak. But the open meeting law itself doesn't guarantee a right of participation. Boise actually just recently hosted Hamilton here in town. And if you went to that, you got to go watch them perform that, but you didn't get to jump up on stage and sing along, with King George or anything. It's the same thing with the open meeting law. So one of the kind of overarching premises of the open meeting law, and you saw this on the opening slide for IDOG as well, is that the open meeting law starts from the basic premise that it's the policy of the state that the formation of public policy is public business and shall not be conducted in secret. And I think that that's an important starting point. And as a starting point, it kind of answers a couple of questions right away. The first question that it answers is, is there a way to get around the open meeting law? And when I read this overarching statement by the Idaho legislature, the answer to that is that's the wrong question to ask. The goal of the law is to allow for business to be transacted in public. And I think that, if you think about kind of where we're at right now, right, one of the big question marks that's out there is, do we have all the information that we need to have? And one of the things to always keep in mind is that in the absence of information, we will tend to fill it in with negative inferences, meaning the more that government tries to keep information from us, the more likely it is that we will fill in that lack of information with a negative inference about what's going on. A great example of that in our everyday lives. Last night, my daughter went out to practice. She's old enough to drive on her own. It was snowing. And so we know generally when she gets home from practice, well, that time came and went. And it wasn't we were thinking, yeah, it's snowing, but we're also thinking, is she safe? Is everything okay? Do we need to, should we call her? And if you think about it in those terms, right, that's a great example of how the lack of information leads you to kind of come to these negative conclusions. It seems counterintuitive at times, right? As government, you may think, look, we've got a really controversial topic. It probably would help us out to sort out our thoughts in private before we go public with it. That's exactly the scenario that the open meeting law is trying to prevent, because of the goal of the open meeting law is to allow the public to observe that give and take and that deliberation of those competing ideas and see how government arrives at the decisions that it arrives at. As we go through this, the presentation is broken down into 5 elements. But if you stick with me for the first 4, you shouldn't have any problems under the 5th, which is enforcement. And so we'll go through some definitions. We'll talk about notice and agenda. We'll talk about the conduct of the meeting, executive sessions, and then enforcement.
So Brian, I please pardon me for jumping in, but as a reporter, I always have questions, and I just feel compelled to ask, was your daughter okay?
Oh, yeah. Yeah, she was just, I mean, that's a fair question. I probably should have cleared that up. She actually was just driving patiently through the snow, and, and so it took her a little bit longer to get back. And between all of us here online, she's a little bit of a chatterbox. And so, you put those two things together, and it took her a little bit longer to get home last night. But yeah, everything is fine. Thanks. As we go through the open meeting law, it's important to understand that the open meeting law is a statute. And so one of the things that I always like to remind folks of is that whenever the legislature creates a definition in a statute, that definition is what controls. And so, for example, if the legislature were to say, look, if it's got webbed feet, feathers, quacks, a bill, and flies, but it's a dog, well, for our purposes, when we go through that statute, that's going to be a dog, even though we're all looking at each other going, that's not what I know a dog to be. And I think it's really important to remember that. And even within the legislature, the legislative world, you can have different chapters or code sections that define the same word or use the same word a little bit differently. And so I think it's always important to remember that as we go through this, because under both these statutes, the open meeting law and the public records law, the definitions are important.
Brian,
yeah,
break in here, but the other day someone said to me, I said the word statute. They didn't actually understand what that meant. And when I told them it was the law, they finally started to get it. A statute is simply a bill that's passed by the legislature, and it's enacted into law. So a statute is a law.
Yes. Statute equals law. Good. So under the open meeting law, two definitions really kind of generate when we have to have an open meeting. The first is decision. So anytime a board is going to make a decision on any issue, motion, proposal, resolution, ordinance, measure, at which a vote is required at any meeting at which a quorum is present. And so if you've got a quorum and you're deciding things, that's a good indicator that it should be done in an open meeting. And then that first definition is expanded by the second definition, which is deliberation. And that's the receipt or exchange of information or opinion relating to a decision, but doesn't include informal or impromptu discussions of a general nature. I like to think of this of if you're on the road to a decision, then those discussions should be taking place under the context of an open meeting. One of the things that comes up is if you really think this through, at times the open meeting law may have have a little bit of a chicken and an egg issue, right? We need to make a decision as to when to hold the meeting. Do we need to have a meeting to do that? And how do we do that if we can't decide on when to have the meeting? The answer is, if you're just scheduling a meeting, there's no problem with that. If it's a discussion of, should we include this on the agenda? There's no problem with doing that. The key is that if you're discussing whether or not to include something on the agenda, you don't stray and start discussing the good and the bad of what that decision point is, right? But if you're on the road to a decision, that's a great indicator. Hey, we should be doing this within an open meeting and getting it on an agenda. Out of these definitions, they apply to public agencies. And public agencies are essentially any state entity that's created by or pursuant to statute or executive order of the governor. It includes regional boards, commissions, counties, cities, school districts, political subdivisions. And then I want to call your attention to this provision down here towards the bottom. Any sub-agency of a public agency which is created by or pursuant to statute, executive order, ordinance, or other legislative act. And so if you have a board that is creating subcommittees, those subcommittees should be operating under the Idaho open meeting law. And I think that that's one of those things that always is important, right? If the board creates a subcommittee to essentially do the heavy lifting for the board, that they're then going to come back and get a recommendation as to how to act, those activities should be in compliance with the open meeting law.
And so, Brian, that means the open meeting law applies to the subcommittee, even if it doesn't have a quorum of the board when that subcommittee meets, correct?
Correct. Right. If the board creates the subcommittee, then it's the quorum of the subcommittee that triggers the open meeting law. Then we get into governing body. A governing body is members of any public agency which consist of 2 or more members with the authority to make decisions for or recommendations to an agency. It's important to understand that in order to be a governing body, it's got to be led by 2 or more folks. And so, for example, the governor's office wouldn't fall under this because it's not a governing body, it's the governor. The attorney general's office wouldn't fall under this because it's the attorney general. It's not a governing body that operates within the office. And so it's important to understand that not everything falls under the open meeting law. And then we have the definition of meeting, and that's a convening of a governing body of a public agency to make a decision or deliberate toward any decision on any matter. If you look at that definition, you'll see that it builds in all the previous definitions that we just went over: decision, deliberation, governing body, and public agency. So that's why all of those definitions work together to create our definition of meeting. One of the questions that we consistently get within our office, and I'm sure we will continue to get it, is, well, if it only takes a quorum of our board, we all know each other outside of what we do as board members. Does this mean we can't go to lunch together, or we can't go to a funeral together, or we can't have a holiday party together? The answer to that question is yes, you can still have those sorts of events. The pause point on those is to make sure that when you attend those events in social situations, you don't talk shop, meaning you don't inadvertently exchange information related to a decision, right? You don't take like a straw poll while you're sitting there at breakfast. And so really, to me, one of the big question marks here isn't, can you go to lunch together? The real question here is, do you have the discipline as a board to go to lunch together? And a great example of that is when I go to social events, a lot of times I will wind up hanging out with other attorneys. We'll talk about, things like movies maybe that we saw, or maybe a vacation, or kids' sports, who knows what it is. But every time we engage in one of those discussions, you always come to this point. And it's a little bit of a pause point. And the next topic that we discuss is most often the thing we have in common, which is the law. So we start talking about work. The same dynamic likely occurs if you sit on a board. And so the question mark is, when you get to that point, do you have the ability to say, hey, we can't talk about this. We got to make sure we don't stray onto this topic. And I think that that's one of those things that is really important for folks to understand. I think the other aspect of this is think about the frequency and appearance of your social settings. And so, for example, if you are a county commission, for example, and you meet every Wednesday morning, well, before your meeting, you have breakfast together every Wednesday morning. What is the inference that your constituents are going to make based on that breakfast? Are they going to think, oh, these guys are getting together to have breakfast and just prepare themselves for the day and, have a healthy start? Or are they going to say they're pre-planning all of the decisions they're going to make at the meeting and cutting the public out? And well, what do you know? They've got the fastest meetings in the whole state because they only ever last 10 minutes and there's no discussion. And so that's one of those things you have to be aware of as you go through these sorts of things. So I'm not saying you can't do it. I'm saying be aware when you do it and make sure you've got the discipline not to stray. All meetings require notice and an agenda. For regular meetings, you have to give at least 5 calendar day meeting notice and 48-hour agenda notice. And then for special meetings, you can't hold them without at least 24-hour meeting and agenda notice. Betsy, go ahead.
I have a question about this.
Yeah.
I have seen, and I have been told about, plenty of meetings by public agencies, boards and bodies in Idaho that don't have a 5 calendar day meeting notice or a 48-hour agenda notice. Sometimes it's less than 24 hours. What can be done about that?
Sorry, my volume was off. Could you repeat that?
Okay, so what can be done when an agency doesn't follow this, when they don't give the 5-day meeting notice or the 48-hour agenda notice, where maybe there's less than 24 hours notice before there's a meeting on important matters that people care about and want to observe?
Sure. And I think that that's one of those questions that we will discuss under enforcement, but that's clearly an enforcement issue, right? You can make an open meeting law complaint that says, hey, we didn't get notice of this meeting. And I can tell you that as an attorney, one of the reasons for why we often recommend that a meeting get canceled is because something went wrong in either the notice or agenda portions of it. And we tell folks, look, don't hold the meeting. Let's make sure we dot all the I's and cross all the T's to make sure that we fully comply with these notice and agenda requirements. And I can tell you that over the pandemic, right, one of the lessons that we have learned in working through the pandemic is, as we have had these meetings that are streamed or done remotely, we've had issues with the notices, because where is the place of meeting? And if folks click the link, but like a letter or a number gets dropped from that very long Zoom link or YouTube link, and folks can't access it, is that something that we need to say, wait a minute, we didn't do the notice right, we have to stop and redo everything? Those become really important elements of this. And I think that, one of the things that I always encourage folks, particularly the folks that advise and work with the meetings, is understand there are going to be glitches. And when you have a glitch, it's better to stop and restart than to try to bulldoze your way through the glitch and create maybe an even larger open meeting law problem for yourself.
In addition to that
question, Betsy?
Yeah, in addition to that, Betsy, that 48-hour notice, I can tell you that Brian and I have called a halt to meetings that had 46 or 47 hours agenda notice, but they didn't have 48. And so we had to call a halt to those meetings so that they could re-notice it, send a new agenda with 48 hours notice.
So one of the other things I want to call your attention to is, under the open meeting law, you do have the ability to have a schedule of meetings. And so if you have a regularly scheduled meeting, so say you meet the second Tuesday of every month, You can post the schedule of those meetings, and then you just comply with the 48-hour agenda notice. One of the things that I think it's really important to note is if you do post that schedule, make sure you check back and that you're complying with that schedule and that you're complying with your 48-hour agenda notice. I know that particularly during the pandemic, we had boards that had regularly scheduled meetings, but then for whatever reason, they would like move the meeting from the second Tuesday to Wednesday. Well, make sure you go back and update your schedule so that folks know how to find when you're meeting. Sorry, my computer is a little laggy. Then I think it's important to note that you can also have an executive session
Brian,
only.
before you go on,
Yes.
why don't you just briefly mention special meetings?
Oh, sure. So special meetings require a 24-hour notice. And I think that one of the things to always remember is that you have to have at least 24-hour meeting and agenda notice unless an emergency exists. And when you look at the definition of emergency under the statute, it means that you've got, peril to life and limb or some sort of financial harm. It should be measurable. It should be urgent. You should be able to articulate why you can't provide at least 24-hour notice. The other requirement under special meetings is that the press can ask to be placed on a list of notice for all special meetings. If the press has asked to be notified of all special meetings, that becomes part of your notice requirement as a board, and you have to make sure that you affirmatively push that notice out to the press because they've asked to be on that list for special meetings. You can have an executive session only meeting. Remember, you have to have at least 24-hour notice. You have to state the reason and specific provision of law authorizing the executive session. And then even if you have an executive session only meeting, there will still be a very small open meeting part of it. And that open meeting part of it will be, we move to go into executive session, your roll call vote, which should all be reflected in the minutes. And if the public, for whatever reason, wanted to show up and see that 5 minutes before you go into executive session, that's the open part of that meeting. And then notice for meetings and agendas shall also be posted electronically if the entity maintains an online presence through a website or social media platform. This requirement has tripped up a lot of folks and really got kind of tough within the pandemic. One of the things that I really recommend with regard to electronic notice is if you have a link on your page that says agenda, make sure the link takes folks directly to the agenda. I actually had an example yesterday where I clicked on an agenda for a meeting and it took me to a page that I then had to hunt down on that page for yet another link to find the agenda. I don't think that complies with the intent of this statute. I think that what they want is they want it to be easy for the public to identify this. So have a Twitter account, it should go directly to either your page that shows where the agenda is, or it should be directly to that. I think one of the elements of this that we have to really kind of work towards is prominence, meaning it should be easy for folks to locate these notices and agendas within these online presences. An agenda is required for each meeting. It's posted along with your meeting notice. You are allowed to amend an agenda after a meeting has started, as well as before a meeting is started. If you amend the agenda outside of 48 hours, you just post the new agenda. If you amend the agenda within 48 hours, but more than 24 hours outside of the meeting, then you post the fact that it's an amended agenda so the public knows something has changed on this. And then once the meeting starts, you move to adopt the amended agenda. And then if you have to amend it within 24 hours or during the meeting, then you would make a motion and have a vote on it. And you should have in the minutes the good faith reason for the amendment of the meeting. And so I think that that's one of those, we want to make sure that you've got all of those steps in there, but it's really important that those steps also get reflected within your minutes. The agenda is required to have all probable topics of discussion. The one thing that I will tell you, and we get a ton of questions about this, is how specific does the agenda have to be? The open meeting law does not say how specific the agenda has to be. It just has to say probable items of discussion. We encourage folks to be specific, but we also understand that sometimes a more general heading works. The one thing I can tell you is that if you have an agenda that simply says new business, old business, that probably doesn't cut it under the open meeting law. And then the other element, and this goes to kind of that specificity, is any item on the agenda that you're going to take action on requires it to be identified as an action item. Just so you know, when you do identify something as an action item, you don't necessarily have to take action on it, meaning the board can look at it and say, you know what, we need more information, we're not ready to act here. But you cannot take action unless you have identified it as an action item on the agenda. And then you do have the ability, like say you learned something during the meeting that requires you to take action, you can again amend the agenda to identify something as an action item. And you have to have that declaration and justification reflected in the minutes. Again, that kind of protects your board as you move forward and take action on these items. All meetings have to be open to the public. I always like to think about this as make sure that wherever you're holding your meeting, the public knows that they can attend. And so, for example, if you have a meeting that has maybe gym doors that are closed and folks don't know that you're meeting in there, maybe a sign that says public meeting, please come in, to let them know that that's where the meeting is. They can open the door. There's no problem there. Some folks go to take the step of making sure that the doors are wide open so that folks know they're more than welcome to walk in. And I think that little things like that go a very long way in helping folks understand that it's an open meeting.
Right.
What happened?
I'm sorry.
Go ahead, Betsy.
Well, how does that apply if it's a virtual meeting? How do we guarantee that it's open to the public?
So how does it apply virtually? So we're going to, let's hold on to that question because I'm going to get to that in just a second, if that's okay.
Brian, what happens if you go to a facility and it says closed to the public, open meeting law discussion?
Well, that happened several years ago with one of our IDOG presentations. And what was interesting was it was actually the media that put up that sign, which was a very funny sort of scenario. But I think that, those are all things that we want to be aware of, right? Is to make sure that wherever you hold your meeting, the public knows that they're able to attend and come in to observe.
I think it was the facility that put up that sign, not the media.
Facility. All right. Fair enough. And then I think, the other element that we've got here is a governing body shall not hold a meeting any place where discrimination on the basis of race, creed, color, sex, age, or national origin is practiced. I think those are all things I'm not aware of any issues with that in Idaho. I will say that within Idaho at times, we get questions about the appropriate spots for where a meeting can take place. And we've had questions that have included, can we have our meeting at someone's house? Can we have our meeting at a church? Can we have our meeting in a bar, in a couple of examples? And the answer to all those questions is yes, but make sure that however you do that, folks know that they can attend, right? If you think about a house, some people are uncomfortable going to a house of someone that they don't know and just walking in, right? It just doesn't feel right. And so that could be an issue that you may want to think about as you schedule that meeting. The same thing with the church. You know, some folks have no problem going to churches of different faith. Other folks maybe are a little bit reluctant to just walk into a church that they're not a member of or something like that. And so I think that you can have those meetings there, but you have to really make sure that folks know that they can go in, that it's an open meeting, that it's okay. Just keep that in mind. All meetings can be conducted using telecommunications devices. Here is one of those areas, and this is going to go to the question that Betsy just asked. The first thing I want to make sure everybody knows is that Idaho's open meeting law does not allow for what's called an all virtual meeting. And so if we were a governing board, this IDOG session would not comply with the open meeting law because it's all virtual. Under the open meeting law, when you have a meeting using telecommunications devices, you have to have a physical place of the meeting that includes at least one board member, the executive director, or the chief administrative officer for that board present. And it has to be a place that they can attend and either listen in or observe, for example, the YouTube stream to watch that meeting. Now, you can have a meeting that has a capacity limit. You can have a meeting that only has one person there, and then maybe it's a speaker or whatever, but you can't do the entire thing virtually. There's a very short period of time during the onset at the very beginning of the pandemic where the governor suspended the in-person requirement, but that suspension expired now almost 2 years ago. And so you can't have a virtual only meeting under the open meeting law. If you are having a meeting that's going to be streamed, or maybe you've got limited capacity because of maybe you've got an outbreak or something, who knows? If you are going to do that, make sure that on all of your meeting notices and all of your meeting agendas, you have a link that the public can listen into. If there's a seating limit, make sure that you put that in the notice or the end on the agenda, right? We only have room for 10 observers. Everyone else is more than free to observe the meeting through this YouTube link or this Zoom link or whatever, or through this phone number for listening in. All of those things become part of that. And so, you know, the answer, I hope that answered your question, Betsy, but if there's more, let me know.
Brian, just to be certain, what we're doing here is not a public meeting because we're not a governing body.
Right. That's why I said if.
Yeah. And I think from what you said, Brian, about the link where the public can watch, that's the key, really, to making sure that the meeting is open, is that everybody has a way, whether they go there in person or they click on the link to see what's going on in that meeting. That means the meeting's open.
Right, absolutely. And I think that, you know, to me, one of the little glitches that has come up more often than not is at times the link will not work when folks are trying to access the meeting. And I think that that's something that you really kind of want to double check. And I will tell you that if I were to create a list of lessons learned from the pandemic, one of the top lessons learned is to double check agendas. Because it's one of those things that we put these together. We've been doing these meetings for a long time, but maybe we haven't gone back and done the extra work to make sure everything's exactly the way it should be. And this is a great opportunity to kind of revisit those sorts of things. Consistent with that, when you're in an open meeting, you can't use computers or texts to conduct private conversations among the board members. And I want to make sure that folks understand, like if you're texting your deliberations among board members, that defeats the entire purpose of the open meeting law. Those things are most likely public records, as we'll learn later under the public records law. And I also want to make sure that folks know when you're texting, you're not as surreptitious about texting as you think you are. And you're not that surreptitious for two reasons. Number one, nobody looks down at their crotch that much. And then number two, nobody ever looks down at their crotch and starts laughing. And so I think it's one of those things to kind of always keep in mind that people can see what you're doing. And if you think about our open meeting law as our ticket to see the show of government, right? People want that engagement and that interaction with their elected or appointed representatives. They want to be able to kind of see the whites of their eyes and understand what the dynamic is among board members and how they're interacting with the public. And so if all they see is the top of your head or the back of a laptop screen, are we really fulfilling that kind of overarching public policy of conducting business openly and engaging with our constituents? When you're conducting your meeting, you have to provide for the taking of written minutes of the meetings, and all minutes shall be available to the public. The law has some minimum requirements for the minutes. It has to include all members of the governing body present, all motions, resolutions, orders, ordinances proposed in their disposition. Essentially, if you have a vote, that vote should be reflected in the minutes, and then the results of all those votes. This is the bare minimum of what's required within the minutes. I think that, to me, folks always say, well, what should our minutes look like? If you want a good example of minutes, go to the legislature's website and pull up any of their committee minutes. And those are a great template to follow. If your minutes look roughly like the legislature's minutes, you're probably doing okay with regard to minutes. The other element that I want to bring up is written minutes means in writing on paper. And so if somebody comes into the office and they say, hey, I'd like to get a copy of these minutes, that means you give that to them. You don't say, oh, here's a recording of the whole meeting, or you can see all of our meetings on YouTube. Those aren't minutes. Minutes are a succinct digest of what occurred within that meeting. And I think it's important to understand that element. The other thing—
written minutes could be electronic. They could be emailed to.
Yeah, they can, absolutely. Yeah, they can be. They need to be written somewhere.
Hey, Brian, this is Scott. I think it's time probably for our first question here. Carrie writes in, what's the time frame for publishing minutes of a city council or any other public meeting?
So that's a great question. And that also is a very frequent question that we get. The law says that minutes have to be made available within a reasonable time. The question mark is, what is a reasonable time? If you're a city council and you're meeting every week, then those minutes should be coming out fairly rapidly, at least once a week, maybe a couple of days after the meeting regarding, depending on what your staff is. If you're meeting every day as a robust, sophisticated county commission, those minutes might be coming out every day. If you're a board that meets once a quarter and you've got, one part-time staffer, and it's hard to get all that out, that may take a little bit longer. There are a couple of other elements here, though. Number one, draft minutes are a public record. And so if you've got a draft that hasn't been approved by the board, you can stamp draft and release those. Those should be released. They're a public record. If you're not getting the minutes out quickly, that might be one of those areas where you're like, hey, we need to make sure that we get these out to ensure that we're complying with this reasonableness requirement under the meeting. Other minutes questions?
You answered my question before I even got to ask it. The draft minutes are public. They have to release.
Yes.
You don't have to wait till the next meeting and when the board approves.
Right. Yeah. And I mean, that's one of those issues that we run into from time to time is folks will say, hey, they haven't been approved yet. That's okay. You can stamp them as drafts subject to change, and that may be in your interest. The other thing that I always like to recommend to folks is, things like minutes are what I call high frequency requests, meaning a board knows they're going to have these things asked for fairly regularly. It may be the sort of thing that you want to have a website where folks can just pull the minutes down. And they're dated, and they say, hey, I'd like the minutes from January 3rd. Well, they're right here on our website. You can have all the minutes you want. You've got every meeting for the last 3 years, all dated. And to me, that's one of those ways that as a government, you can get out of that request and response business to some degree. Executive sessions. So under the law, you are allowed to have executive sessions where members of the public are excluded. You have to have a motion to go into executive session that identifies the specific subsection that authorizes it. And you have to have a roll call vote on motion recorded in the minutes. And so a roll call means you call each individual board member as opposed to like a unanimous consent request or something like that. It has to be a roll call. And then it's authorized by a 2/3 vote of the governing body. So quick math problem here. If you have a board of 5, how many votes do you need to go into executive session? Hopefully everybody got to the same answer, which should be 4. Because 3 is not 2/3. That would only be 60%. And so you do need 4 votes on a 5-member board to go into executive session. A very common question that we get under executive sessions: who decides who goes into the executive session? The answer to that is the board decides who goes into executive session. And I think it's important to note there are a couple of things, right? Number one, understand that the executive session is designed to protect confidentiality for some reason. And so the best way to identify this or explain this is, does anybody know what Benjamin Franklin said about secrets kept among 3 people? The answer is, Ben Franklin said, the only way you keep a secret among 3 people is if 2 of them are dead. Now, I'm not advocating for that as a solution to protecting confidentiality, but I think it has a very important cautionary element, meaning the more people you bring into an executive session, the harder it is to protect that confidentiality of that session. And so I think that that's something to really keep in mind when you have executive sessions. You want them to be small in the number of people that are in there, and then small in the length of time that you're in there to protect against drifting off topic.
Brian, what
yes.
about, people that come and attend an executive session because they've been invited by the board, and then they go out and blab it to everybody?
So that's another question, as you know, that we get quite a bit. And under the open meeting law, that's not an open meeting law violation. So the blabby executive session attendee is not necessarily is not a violation of the open meeting law. There's nothing that prevents it. But again, right, that's a cautionary element for when you use and go into executive sessions. And, members of the media have built careers on the fact that they've got folks that are willing to talk to them about what goes on in an executive session. Is that correct, Betsy?
There's no penalty. First Amendment, freedom of speech.
So then when you go into executive session, you can go in for a number of reasons. But I want to highlight that as you go into executive sessions, each one of these reasons revolves around a specific element, meaning you should be able to identify something very specific for why you're going into the executive session. If you're going in generally, then you've probably got a problem with your executive session. So the first one, hiring a public officer, employee, staff member, or individual agent. The respective qualities of the individuals are to be evaluated in order to fill a particular vacancy or need. In this instance, right, if you read through this, you should have an identifiable position. We're hiring for position A, and we have candidate A, or maybe you've got candidates A, B, and C. So that's very specific. It's not, hey, we've got a bunch of openings, should we fill them? See the difference there. It's specific versus that general. Same thing with the next one, right? Evaluation, dismissal, disciplining, or hear complaints, right? You should have a specific evaluation or complaint, and then it's against a specific person. One of the things that we were asked to look into several years ago was a board went into executive session because the public was very unhappy with their board. And so they wanted to go into executive session and talk about all the reasons why the public was unhappy with the board generally. That probably doesn't fit under that executive session, right? Because it's not a specific complaint about a specific person.
That may even be an example of why the public was so unhappy with that board.
Well, very true. To acquire an interest in real property not owned by a public agency. And so this is a very specific provision. You have to be a public agency interested in acquiring a piece of property. And really what this is doing is it's kind of protecting your purchasing ability as a public entity. To consider records exempt from disclosure. This means if you go in under this provision, there should be a record that you can point to that says we are going in there to discuss this record that's exempt from disclosure. Preliminary negotiation involving matters of trade or commerce, which the governing body is in competition with governing bodies in other states or nations. And so again, if it's, for example, you're trying to determine whether or not you've got the right economic incentives to woo Costco to your neighborhood, you should be able to say, we are in preliminary negotiations with company X, right? You wouldn't disclose who the company is because that might defeat the purpose of the executive session, but company X to come to this community or something to that effect. It should be specific. It should be the sort of thing that if a judge said, I want to know who this is with, you could identify somebody specifically.
So Brian, I do have a question about the purchase of property not owned by a public agency. I have had some people from public agencies will say to me, well, why can't we also have a closed meeting to talk about selling property that is owned by a public agency? And my answer has always been, why would you want to do that? There are very public processes you have to go through to sell public property. It seems to me that a public entity isn't allowed to play hide the ball to try to gain things and get a bigger profit. And we saw a very good example of that just recently when the land board auctioned off some property and got, even in a public auction with everything out on the table, got far more than they expected to. Why is there the difference there between buying and selling?
So I think that's a great question, but it's probably a question for the legislature. I mean, the legislature is the one that put that together. And I think, as you observed, Betsy, I mean, they did so fairly purposefully. The legislature said we're only doing it for when we acquire property, not for when we're getting rid of property. And if you compare, as you noted, right, these provisions with the way that government gets rid of like surplus property or real property, those, as you observed, are somewhat public processes. And I think that if you think about it logically, right, one of the things that you want to be, that again, if we think about this from the absence of information element, if we close off those liquidations of properties, well, then the inference is going to be, oh, that person has a cozy relationship with government and is therefore getting an inside deal. Right? That could be one of the inferences that occurs. And so by the legislature saying, nope, we're going to limit it to this circumstance, and then we've got a whole different series of statutes for liquidation of property, we navigate that somewhat difficult scenario.
And Brian, in that regard, it's only when the public agency is purchasing property from a private party. It's not when it's purchasing property from another public entity. So
right,
it's
because
more narrow. And
exactly. And it's because, again, right, if the public entity is liquidating the property, that's a public process. So how do you then close it off by then saying, hey, we might be contracting with this other public entity?
And by the way, on our little discussion on executive session blabbers, there may be other impacts with regard to the things that they say, but there's not an impact under the open meeting law.
Correct. There's an exception to communicate with legal counsel to discuss legal issues for pending litigation or controversies not yet being litigated, but imminently likely. And so, for example, if you either have a lawsuit filed or you know that you're likely to have a lawsuit filed, for example, maybe you've gotten a tort claim, or maybe somebody comes in and reports, hey, I was driving the snowplow yesterday and I ran over a dog, for example. Well, we're probably going to get sued, so we may want to talk about what's going on there. This is not an exception to just go in with legal counsel and get general legal advice. This is only for scenarios where there's pending or likely litigation. You have the same ability under with regard to risk managers or insurance providers with regard to claims and settling or resolving claims that are either already filed or very likely to be filed, the same sort of analysis.
And Brian, we held a public meeting, and I was interested in somebody else's lawsuit. So don't you think we should be able to do that in executive session?
Well, what do you mean interested in somebody else?
It was Jones versus Hamilton down the street, and I thought it was an interesting case.
Oh no, that's not what these exceptions are for. They're narrow, right? It's got to be the public entity is involved or likely to be involved in litigation, not for Monday morning quarterbacking other litigation. Which then, I mean, and some of these questions are kind of answered by this provision of the open meeting law, right? The exceptions to the general policy in the executive session section are narrowly construed, right? And so if you are interpreting these in a way that kind of broadens their reach, like more generalizes how these should be interpreted, the law actually says that's not how we interpret this. And so we narrow each of these exceptions in, which is why, as you go through these, one of the best checks on it is each time to say, can we identify a specific item that we're discussing? And if your conclusion is ever, it's about general things that we want to keep confidential, that should be a very strong cautionary note with regard to executive sessions. And then it's a violation to change the subject within the executive session to one not identified within the motion or to a topic that is not provided for. And so say you go into an executive session and all of a sudden, as part of your hiring, you hear a complaint about someone and you're like, oh, you know what, maybe we should see if that's a disciplinary issue, but you didn't go into executive session for that. You can't just change the topic in there. If you really had to deal with that, the solution would be to come out of executive session, make a good faith motion to amend the agenda to include a new topic for executive session, and then perhaps to go back into executive session. And then the same thing, you can't, once you get into executive session, say, whoo, thank goodness we're in executive session, let's get the real business done. That's not appropriate either. And you have to be really careful with an executive sessions because it's easy to drift off topic. A scenario a few years ago where a board went into an executive session to evaluate candidates for an open position. So very legitimate purpose for going into an executive session. But while they were in there, one of the members said, well, this will help us fill several of our open positions. We should be looking a little bit better into the future. Another board member said, well, why do we have so many open positions within our entity? Okay, so you see right there, they're starting to drift off topic. That was the answer to that was, well, we haven't had enough money in our budget to fill those positions. Well, why haven't we had enough money in our budget? And you see how now we're not talking about that candidate for that position. Instead, we're talking about the entity's budget. That's a great example of how easy it is to drift off topic. And so one of the things that's really important to have is to ensure that everyone within your executive session is empowered and enabled to say, wait a minute, we can't discuss that topic in here. If we need to discuss it, let's get it on an agenda at a future meeting and have that discussion. It's really important that when you go into executive session, it is everybody on that board's responsibility to stay on topic and keep the remainder of the board on topic within that executive session. One of the other things that I will encourage folks to do is when you go into an executive session, one of the best things that you can do to help with transparency is to time stamp your executive sessions. And so, for example, if you go into an executive session to discuss the filling of a vacancy, into your minutes, entered executive session at 3:04 p.m. to discuss the filling of vacancy A with candidate X. And then at 3:15, ended discussion of candidate X or candidate A for position X. And that way the public can say, oh, they were in there, they discussed that for about 15 minutes, 10 minutes. That makes sense to me. sounds like a good, efficient executive session. It also works if you have to go into executive session for more than one topic, right? You can say we went into executive session at 3:04 to discuss filling vacancy. 3:15, finished that, began discussion of acquisition of piece of property. 3:30, finished that discussion. And again, the public can kind of review those minutes and click through them and say, oh, the board's functioning kind of efficiently, doing the things that we think they should be doing. They're not wandering. You know, if you're in executive session for 2 or 3 hours, that should be a cautionary flag for you as a board.
Brian, that's all fine and dandy, but we're very close as a board, and we don't want to air our dirty laundry in public. So we should go out into executive session and hash it out, and then we should come out singing Kumbaya.
Well, that may be a more efficient way to do things, but under the law, there is no dirty laundry exception for executive sessions. And so it's one of those things that, just like you don't want to have a breakfast pre-meeting earlier in the presentation, you don't want to have, kind of an air clearing, general executive session. There's no provision for that. That is a violation of the open meeting law. And it's one that we've investigated many times over the years. Along those lines, you can't take final action within an executive session. And one of the questions that we get a lot of times out of this is, well, what if we're like discussing the resolution of a lawsuit and we all kind of come to an agreement of where that should go? We can't go out in the open and say, hey, we've agreed as a board to settle this lawsuit for between $25,000 and $50,000. Because the minute that you go out and say that, the lawsuit essentially automatically goes to $50,000 at that point. The answer there is you can generally tell within a board when you're reaching a consensus in a discussion. And when people start repeating themselves or the discussion starts getting a little circular, that's a great indicator. Hey, it's time to get out of this executive session. And then you can say, if you need a motion, for example, you can always come out and say, we move to adopt the recommendation made by our attorney in executive session. You're done. You haven't given away anything. You've given all the requisite approval. You protected all of your decision-making capability within that, which also goes to, the minutes. You have to keep minutes with an executive session, but they do not have to contain information sufficient to compromise the purpose of going into executive session, which is why, I recommend having that kind of timestamp diary of what you did within the executive session. Those minutes don't really tell you a lot. It's by design because you don't want to defeat the purpose of that executive session. There is a requirement under the law for entities that negotiate unions to have all negotiations in executive session. And then again, there's two very specific elements where you can go into executive session to consider a labor contract offer or formulate a counter offer, or to receive private information about a specific employee. And so again, very specific circumstances. And if you do need to go into an executive session, you want to make sure that you reflect that's why you're going in for that executive session. Then we get down to enforcement. A few things with regard to enforcement. Number one, if you don't comply with the open meeting law, it renders whatever the board action is null. That is not self-executing, meaning someone has to say you violated the open meeting law. That decision is set aside. It could be done by a judge. It could be done by the board. The board could say, hey, we messed up the open meeting law. We're not abiding by that decision anymore. We're setting it aside, and we'll take up that matter at a future, properly noticed, properly held meeting. And then if you participate in a meeting that violates the open meeting law, you could be subject to a civil penalty that's payable by you individually. The board or the government entity doesn't pay the fine for an open meeting violation. It comes out of your specific wallet. Any violation is $250, $1,500 for a knowingly, scripted sort of violation, and then $2,500 for repeat violations if it's multiple ones within a 12-month period. For enforcement of the open meeting law, the Attorney General enforces it with regard to all public agencies of state government. Prosecuting attorneys enforce it with regard to all local entities within their jurisdiction, so within the county. And then the last part is any person who feels that that's affected by a violation of the open meeting law can bring an action against it. And so, for example, if a board decides something that affects your property and you don't think that they complied with the open meeting law, you can bring that action as an open meeting law complaint.
Well, Brian, the library district held a meeting. I think they violated the open meeting law. And I went to the prosecutor and he wouldn't do anything. And I called your office and you said, no, you just don't want to help me.
Well, it's not that we don't want to help you. As you know, we do want to help folks as much as we possibly can, but the law sets forth this is how the jurisdiction works. And so you do have to go to the prosecuting attorney, or you can bring your own action. Our office doesn't have the authority to get involved in these sorts of things unless we're invited by our prosecuting attorney. And that does happen from time to time. You can also cure violations of the open meeting law. So an entity, if a open meeting violation is brought to their attention, they do have the ability to cure the violation. It requires that they recognize that the violation has occurred, and then they set aside any decisions that need to be set aside, and then they take appropriate action. A lot of times what that means is that they will have the meeting, they will redo the meeting from the start. And I think it's important to understand that within the context of curing open meetings, sometimes one of the most difficult things for a government to do is to say, hey, we made a mistake. But I want to offer to you kind of two scenarios for how that can occur. In scenario number one, we had a board that violated the open meeting law. It was brought to their attention that they violated the open meeting law. They said, oh, you're right, we violated the open meeting law. We're going to redo everything. And that was the end of it. I think that, there was a very small blurb that said board has redone their meeting because they failed to post their notice properly. And that was the end of it. That's scenario one that I offered to you. Scenario two, we went to a board and we said, hey, we think that you violated the open meeting law. Would you be willing to go through some training and we'll call it good? And they said, nope, we didn't violate the open meeting law. And we said, are you sure? Because we're going to file a complaint. And they said, nope, we didn't. And so we filed a complaint. Well, the minute our office files a complaint, that becomes front page news. And so the news says Idaho AG's office files open meeting complaint against board. They write all their stories about it. The judge comes down and says, hey, you violated the open meeting law. The board says, no, we didn't. We're going to appeal it. Well, that starts a whole nother round of news, right? And it goes on and on and on. And it's one of those things that I think it's important to note, right? You've got these news articles that are coming out that are kind of front page. You've got the editorial page kind of teeing off on why can't these guys just follow the open meeting law? And then it gets all the way through that. And then there's also a follow-up article of like how much taxpayer money went into defending this open meeting violation and why are they doing this? Those are the sorts of things to keep in mind. Whereas sometimes if you just say, hey, we messed up, you've got a really clean, easy way to fix it. And it's built into the law. And so I always offer that up because with that ability, it's just a very easy way to get out of an open meeting violation and to say, hey, we want to make sure that we get it right.
Brian, in that scenario number one, the entity that found that they had violated the open meeting law, do you know who that might have been?
It was the land board.
Right.
Of which the Attorney General is a member.
And we corrected it. It was not an intentional error, but it was an error, and we had to go back and redo the entire meeting because of that error.
Correct. We've created some charts and checklists to kind of help you navigate through these. We've got an open meeting law checklist for regular meetings. We've got one for special meetings. We have one for executive sessions. We have one if you need help creating an executive session motion. And then how to amend the agenda. And so hopefully what this is it creates a whole list of tools that enable you to easily comply with the open meeting law. I think it's really important to understand the open meeting law is not designed to litigate over the open meeting law. The purpose of the open meeting law is to encourage and incentivize government to comply with the open meeting law. And I know that our office's approach with that is fairly consistent with that, right? We want to say, if you messed up, here's how you messed up, how you can fix it in the future. Maybe you need a little bit more training. The goal of the law is compliance. With that, I'm happy to take any questions.
Well done, Brian. Just for everyone's understanding of how this is going to move along, we're at 3:15. We advertise this as about a 2-hour session. We have more time to go long. I would say at this point, we probably will. The public records presentation, though, is shorter than the open meetings law, so it's not necessarily a symmetrical half and half. But a reminder that this will be archived online. So if folks can't join us for the entire discussion, we will put it up online so you can have it. I'm seeing some asks about the open meeting slideshow. It actually is a public record and it will be made available. So to those of you asking if it's available, yes, we will either put it on our website or I'll just ask folks to get a hold of me and I can provide it to you, but we will get that to you. Brian, we'll do kind of a lightning round of questions. HOAs, the legislature, and political committees, are they subject to the open meeting law?
So HOAs are not, those are private entities, and we get a ton of questions about HOAs. I do know that the legislature has had some discussions in the past, and I wouldn't be surprised if there's legislation brought this session or next session. It's one of those things that rotates through depending on the year and who's got a favorable ear. That one. The legislature is governed by by both the Idaho Constitution and their own rules of procedure, and each chamber actually has rules that roughly mirror the open meeting law. They have specific exemptions for executive sessions. Almost all of their meetings are open. Now all of their meetings are streamed. They very rarely go into executive session.
And the other question, Brian, was about county central committees, legislative district committees.
Oh, okay. Yeah. And so party committees are matters of party business. They don't fall under the Idaho open meeting law, and they generally conduct their business in accordance with their own bylaws.
Brian, a local school board stopped letting parents ask questions at meetings. Questioner writes, instead, they require parents to submit questions via email. Now we don't know the questions being asked nor the response to those questions. Can this be done legally in accordance with the open meeting law?
The answer to that is yes. And again, right, if you remember at the very beginning, the open meeting law is just your ticket to observe the show. The government entity has the ability to regulate how that interaction occurs if they allow for that interaction. And so what this really is it's more of a political question than an open meeting law question, right? Are they addressing the needs of their constituents in the way that their constituents feel they best should be addressed? So much more political than an open meeting law question.
You said, Brian, that the members of the media in a particular area can get on a list to get meeting notices automatically sent to them when there is a new one. Is there some mechanism for the public under the open meeting law to be added to that list as well?
So I believe under the law, it's just for the press, but let me do a quick check here. Yeah, and so here's the exact wording from the statute. The secretary or other designee of each public agency shall maintain a list of the news media requesting notification of meetings and shall make a good faith effort to provide advance notification to them of the time and place of each meeting. And so it's specific within the statute to news media. That doesn't mean that as a constituent, you can't ask to be placed on the list. The worst response you can get is no. But again, that's a political answer as opposed to an open meeting law answer.
Can you discuss what constitutes a serial meeting with a non-elected official, parentheses, administrator, asking individual city council members to vote a certain way?
So, first of all, I would discourage, kind of that pre-polling, particularly if it's done in that sort of fashion, right? Because that seems like it's fairly clearly being done in an effort to avoid the open meeting law. The question mark, though, is if the information is only between individual members to that staff member that's not a member of a board, well, that may technically not violate the open meeting law because the deliberation isn't occurring between the board members and they're not getting that quorum. But that really is going against what I think is the very spirit of the open meeting law. I think it's okay to share information, but I think that when you take that extra step of polling, it's not a practice I would recommend.
This is a question about meeting minutes. What if an ordinance is passed, but the minutes do not reflect what the ordinance says or discussion on parts of an ordinance?
So if you remember, we had a slide that said, here is the bare minimum that minutes have to include. And I think that when you look at that bare minimum, it's not a lot. Like, you can get by with some fairly skeleton minutes. In the interest of public disclosure, I think that, in certain circumstances, when you've got an ordinance and there's give and take, you may want to make sure that the minutes reflect that there's give and take and that there's differing views. They can be very succinct, but you do want to have that digest within the minutes.
Brian, can you reiterate if there's any aspect of an open meeting process, from meeting notices to the delivery of minutes and anything in between, who has the authority to compel enforcement, if you will, at the local level and the state level?
So at the state level, complaints would come into the Attorney General's office. So it involves a state agency or a state board. That complaint would come to the Attorney General's office. If it's a local entity like a city council or a mosquito abatement district or a library district, those complaints would go into the county prosecutor's office.
And you mentioned that there is a private enforcement mechanism as well, that a person.
Correct, there is. Any citizen affected by a decision can bring a civil action.
Okay. And that's essentially a lawsuit.
Yes, it is a lawsuit.
Okay. So that does it for the vast majority of our open meeting related questions. I think at this point it's probably, based on our clock, probably time to take our 5-minute break. Betsy, I'll defer to you.
Yeah, well, no more than 5 minutes. We'll be right back to go on to the public records law, and we'll talk to you all in just a few minutes here. Okay, Scott, we ready?
I'm ready.
All right.
So
he's going to be getting the next skit queued up. As we turn to the public records law, we have another skit to watch, and this one is entitled Know Your Business. So in this case, it is featuring Trudy the clerk and a citizen by the name of J.Q. Blusterfelt. Let's see how we do on getting this one rolling.
In this round, we observe how a citizen's request for records can be made more efficient with experience, knowledge of the law, and a little bit of patience. Trudy the clerk now works for the local school board office. She's about to receive a call from a difficult citizen, John Q. Blusterfeld.
Good morning, school board office. This is Trudy. How may I help you?
Well, first of all, Trudy, if that's your real name, it's about time somebody picked up the phone. That took almost 2 rings, and that's my tax dollars at work.
We'll work on that.
I'm J.Q. Blusterfeld, and I want a copy of every single letter from Superintendent Chase to the school board. Every single one of them. All of you school people over there are all in cahoots about this new redistricting plan, and I won't stand for it.
You want every letter the superintendent has sent to the school board?
And every email, too, and I want them today.
I'll do what I can to get that for you. There are probably quite a few, and I'll need some time to go through the school board's correspondence file.
Now, don't you be trying to stonewall me. I know my rights. You can't push me around. I'm going to expose that superintendent for the crook he is. Now, I want those letters ASA pronto.
I'm not trying to stonewall you, Mr. Blusterfeld. There's just a lot of correspondence to go through. Could you tell me what specific letter you're looking for?
No, now you can't ask me that.
You're right. I am not supposed to ask questions about your request, but I could get you the letters more quickly if I had an idea about what letters you're looking for.
Aha! Now you're trying to sound like you're assisting me. Unless you're trying to assist me. You're trying to assist me, aren't you?
Absolutely.
I guess I always assume that the government is hiding things from people. I'm sorry if I came on a bit strong. I'm trying to find the letter where Superintendent Chase puts in his 2 cents about the realigned school boundaries. Now, the kids on Walnut Circle now have to go to Jefferson High. And you know what that means?
That sophomore sensation Cleet Stevenson won't be playing quarterback for Central High this year.
It means that sophomore sensei, yes.
I know what letter you're talking about, sir. I can probably locate it in 15 minutes. You can pick it up or I can fax it to you.
I'll pick it up this afternoon. My Conspiracy Book of the Month Club meets downtown anyway.
Perfect. By the way, the school board boundary plan had a public hearing last month. If you missed it, I could get you a copy of the minutes. We have a typed transcript or a videotape presentation if you prefer.
That'd be great, Trudy, if that's your real name.
And we have a win-win situation for public records. A knowledgeable public employee and an amenable citizen working together for a common goal. In the arena of public records requests, here are a few important things to keep in mind. Most documents are open to the public, and records are not limited to paper. They can also include email and audio or video recordings. Every public office should designate an official who is in charge of records and who knows where documents are kept. Clerks cannot ask why someone wants a specific document and must turn them over in a timely manner. However, clerks may ask questions to help the citizen narrow down exactly what documents they need. Always endeavor to work together. And that concludes our exploration of how public records laws work for the public good. If you're interested in having a rule book handy in your office, check out our website at idahoptv.org/OpenIdaho. Open government is everyone's right. It requires fair play and teamwork.
Well done. That's an award-winning performance, I'm certain. But with regard to public records, if it's in writing and it doesn't concern litigation or personnel matters, typically it is a public record that's going to be subject to disclosure. And as a record, that includes all writings, includes tapes, photographs, electronic data, this YouTube video, text messages, and emails. We've had a number of instances where people say, well, it's not a writing, it's an email, and the answer is that is a writing. But also, when you think about that, asking a clerk to gather more than you need is a waste of time and taxpayers' money. And in this case, the clerk's asking why a document was sought. The clerk saved everyone's time. In fact, the legislature has amended the law to allow the agency to provide information which may help the requester narrow the request. And then in this case, as it turned out, the follow-up report demonstrated that there had not been any kind of untoward activity. So in this case, a little sunshine quelled the rumors, which are always nearly worse than the truth. One thing I think would be important to remember here is the old adage that you catch more flies with honey than you do with vinegar. And meaning that if each side's willing to treat each other with a little bit of honey instead of vinegar, things work a whole lot better, both by those who are in the public and those who are in office, those who are in the media, who are able to talk to each other in a meaningful way. It's a lot better. All of us can get along, and the information can be provided appropriately. Betsy or Brian, I think.
Yep, we'll go into Brian next.
All right, thank you. Before we embark on public records, I did get one additional question on open meetings law. And the question was, what is meant by imminent litigation? If you remember, under the executive session exemptions, there's a provision that says either currently litigated or imminently likely to be litigated. Imminent means you have a reasonable certainty that you're going to be sued, or it's more likely than not that you'll be sued over an issue, or that you're going to bring suit over an issue. Meaning, again, right, you can look on the horizon and you say, oh, there's a lawsuit out there somewhere that we can identify. With that, we're going to go into public records law. And the Idaho public records law, sorry, just navigating the technology here. But under the Idaho Public Records Law, if you remember, that's our red book. And under the red book, one of the things that I always like to think about is if our open meetings law is our ticket to the show, the Idaho Public Records Law is our fishing license. And what that, and really one of the things that we've heard from folks is, you know, the public just want, or the media, whoever it is, they just want to fish around and see if they can find something on us. And the answer is, well, the Idaho Public Records Law actually gives folks the right to kind of fish around in those documents and take a look at what government is doing. And again, it's one of those, if you think about both of these laws, the open meeting law and the public records law, they're both citizen oversight mechanisms, meaning it's how the citizens keep track of the government that they've chosen to represent them. And I think it's important to kind of keep that in mind when you think about these laws in those terms. We're still dealing with our rules of statutory construction. So if the legislature has offered us a definition within the law, that's the definition that controls. And those definitions become really important within the context of the Idaho Public Records Law. Under the law, we've got a few key definitions. One is custodian. The custodian is the person that has the personal custody and control of the public records. And so one of the things that I always think it's important is each agency or entity or government or subdivision, whatever you want to term them, they should have somebody that's designated as essentially the keeper or custodian of the records. That's where the public records requests get addressed. That's where they kind of all flow through. And the law actually requires that that person be designated, and it should be somebody that you can identify. If I say I call up our office and I say, hey, I want to get public records, who should I address that request to? There should be an answer there. And I think that that's one of those things that really helps with these sorts of issues. Writing includes but is not limited to. So remember that it includes, but is not limited to handwriting, typewriting, printing, photostating, photographing, and every means of recording. So when you look at this definition, you can see, okay, this is a little dated, right? Photostating. I don't think anybody is still photostating anymore, but that doesn't matter because it includes every means of recording. And then we get into state agency, every state officer, department, division. We've got public agency, any state or local agency. That's if you're in government under this, you are under the public records law. And then we get down to public record. Any writing containing information relating to the conduct or administration of the public's business. And there's a new provision here. Personal notes created by a public official for their own use unless those notes are shared with others or the entity. And so, for example, if you have an agenda that's sitting on your desk that you write notes on, and then it's collected up at the end of the meeting by the clerk, those are public records at that point. If it's an agenda that's sitting on your desk that you slip into your folder and go home with and don't show it to anybody, that's not a public record. And so it's important to understand that you do have the ability to take your own personal notes, but once those notes are shared with anyone else or the entity, then that exemption lifts from those personal notes. The other really important element is any writing containing information relating to the conduct or administration of the public's business. If you remember our earlier definition of writing, it includes every means of recording. When you put that definition together with public record, it establishes that Idaho is what's known as a content-based state, meaning the content of the record is what determines whether or not it's a public record, not the means. There are certain states that have what are called a mean state, meaning if this is a publicly provided device, then all records on it are a public record. Same thing with a public computer or a public phone if you've got voicemails or whatever. Idaho is not that. It's a content-based state, which means that even if you're using a Gmail account but transacting public business, those are public records. Similarly, if you've got your own personal device and you're texting, for example, among members of your office about some sort of public issue, those are public records. That also means that if you've got, for example, a government provided device and your spouse texts you and says, hey, can you pick up a gallon of milk on the way home? That's not a public record because that's not transacting public business. And so it's really important to understand that you can have public and non-public records in the same mechanisms. The real test is what does the content of the record say? There's a case in eastern Idaho, and it involved two legislators, and one of the legislators recorded the conversation that went on. And part of the conversation had to do with proposed legislation that would come before the legislature in the next session. And then there was a second part of the conversation that related to some party business, business going on within the political party and, whatever's happening there. It went in front of a judge, and the judge said all of the recording that addresses this potential legislation is public, but all of the recording dealing with the party business is not public. And so that's a great example of how even within the same recording, you can have public and non-public elements based on the content of that record. Under the public records law, every person has a right to examine and take a copy of any public record. And so you can look at it and say, I want a copy of these 5 records, or I just want copies of all these records. It has to occur during regular office work hours. And so you can't have like a public records special, all the records you want to see after midnight. It has to be during regular office hours. And then you can establish a copy schedule for that examination. If you do establish a copying fee, there are some restrictions on it, right? It can't exceed the actual cost to the agency. It's at the lowest person on the staff capable of handling the public records request. You can establish a key to recover the actual labor, but the first 2 hours of labor and the first 100 copies are free. It's the first 2 and 100 copies. And so, for example, if it takes me 2.5 hours to fulfill a public records request, I can only charge for the half hour because the first 2 hours are free. Similarly, if Betsy, for example, were to make a public records request of us and it resulted in 120 copies, I could only charge her for 20 copies, not the 120. And I think that that's important. Government is allowed to aggregate, repeat, and continuous requests. So if you come in and you request, essentially 20 copies every day for 2 weeks, you can aggregate those and say, hey, you've hit your 100 copy limit at this point, and now we can charge for those requests. And then we can also require advance payment under the law. And that payment is because government at times has been the victim of voluminous public records requests that they've compiled. And then, for example, within our office, we had a public records request for a huge number of documents. It probably came out to about $12,000 in labor and copy costs when all was said and done. And then when we said, hey, your public records are ready, the requester said, oh, we just wanted to see if you would comply with the law. They didn't even want the records. And so, and it's important to understand that that's your taxpayer money that goes into complying with those. And so advance payment is required. I will say that if you have an advance payment on the government side, make sure that that is itemized, meaning we anticipate that this will cost X number of hours to be performed by staff member at X rate. It will result in X number of copies. Here is your first 2 hours and first 100 copies for free. And then here's what the remainder would be. We've gotten one of the complaints that we get from time to time is folks will call us and say, we made a public records request and they said that it would cost $1,000. And our question is always, well, is that 1,000 broken down? And they're like, no, it isn't. Under the law, it should be broken out. Was there a question?
Brian, if I may, I just wanted to jump in and say that the first 2 hours and 100 copies free are perhaps my favorite amendment that the legislature has made to this law in recent years. This makes the vast majority of public records requests in Idaho free of charge and ends a whole lot of waste of time and bureaucratic haggling over a $2.75 fee and things like that. So unless it's some huge voluminous thing, most of the time there should not be a charge for a public records request.
And I think that's a good observation.
Hey, Brian, what
Yes.
about any potential recourse that a requester has in that situation where they get a quote for fulfillment that appears to be exorbitant, that perhaps was made in bad faith because I'm really busy this week and boy, I don't want to fulfill this, so I'm going to say it's going to cost $3,000. What is the requester's recourse in that situation?
So under the law, you've kind of got two avenues for recourse. Number one is you can contact the agency and essentially say, really, can you itemize this and tell me how this is broken out? Is there a way for me to narrow the request? Maybe I can ask for something more specific. Or you go to court and you say, this is way beyond what I'm asking for, and this is just a delay or obfuscation tactic by the government. Unfortunately, there's no like interim step of like where you like call in an arbiter or something and say, hey, is this a real number or not? You can either work back through the agency or you go to court. Which actually, go ahead, Scott.
You said that, just a point of clarification, that 100 copies, forgive me if I'm incorrect, you're the attorney here, but isn't it 100 pages? And that
it is 100 pages, okay. Yes.
Just for clarification, so everybody's on the same page there.
Yeah, 100 pages. Sorry. So then when you get a request, how are they responded to? First, you can grant or deny the request within 3 working days. And so you've got 3 days to either grant or deny it. If you have a longer period of time to locate or retrieve the record, you can let them know, look, we need more time to locate this, or you've asked for a lot of records. It's going to take us some time to compile this. Then you can get 10 days from the date of request. And so there's a couple of things I want to make sure folks understand. It's not 3 plus 10, it's 3 or 10. And then it's only to retrieve the records, to locate and retrieve them, or to redact non-public information from the records. It's not, I need 10 days to sort out whether or not we're going to grant this request. You indicate that in writing, you send a letter, we call it a 10-day letter within our office. Under the law, you do have the ability to contact the requester and ask them to narrow the request, like say, hey, you've requested a lot of records here. It's likely that that's going to cause you to make a payment. Do you want to narrow it? The law was recently amended to allow for an agency to require more specificity, including a date range for documents. And so you do have that ability. When you respond to the request, if you've got exempt material and non-exempt material, you want to separate those and hold on to the exempt material, because if your exemptions are challenged, then those are the documents that you're going to wind up having to put in front of the judge. If the agency fails to respond, it's deemed denied within at 10 days following the request. And so if you make a public records request and you hear nothing for 10 days, then you consider it denied. And that's important because under the public records law, that starts the clock ticking for you to bring an action challenging that denial. If you deny the request, you have to notify in writing of the denial or a partial denial. And so say somebody were to ask our office for a roster of all of our employees, and for whatever reason, the only roster we had all of our social security numbers on it. Well, we would redact those social security numbers, but that would also constitute a partial denial of that record. And so it's because that information is exempt from denial. So we have to say, this is a partial denial of your record. This information is exempt under Idaho Code 74-10. We'll get to it in a second. And then you put that in the letter. In the denial, you have to indicate the specific exemption that you're relying on for the denial. That's the statutory reason for it. And then there's also information that you have to include that includes you have a right to appeal the denial. Under the law, the sole remedy is an action in the district court where the records or some part of the records are located within 180 days. You have to put that into your denial. And then you also have to include in the denial that an attorney had the opportunity to review it, or you didn't give it, or you chose not to have an attorney review the denial. And all of those become little steps, because one of the remedies under the Idaho Public Records Law includes a bad faith remedy. And so if you leave any of those portions out, you may be putting yourself into a position where you're open to a bad faith claim, meaning you denied this and you didn't go through the necessary steps for that denial.
So Brian, what about this clause where it's deemed denied if they simply don't respond for 10 days? They haven't done any of those things they were supposed to do.
Right.
Is there a penalty for that?
So there could be a penalty for that, right? That could be one of those indicators of bad faith. If you get a public records request and you simply don't respond, and then you don't have any basis for that exemption, then you could wind up in a bad faith scenario. Now, let's assume, for example, that you made a public records request for records that don't exist or something. Arguably, your non-response may be defensible in that position, but you're in a much better place to say your records are denied because they simply don't exist. We don't have them. Because now you're putting it in a position where you've got a clear track record of how that progressed. Our recommendation is that you respond to everyone within the timeframes and with the information that's required under the law. In the last couple of years, we've had a few newer exemptions, and I call them newer exemptions because they have come into being since the last time we've done an IDOG presentation. So I've kind of collected them all here for folks so that they're kind of top of mind. We've got records of the criminal justice integrated data system received by the state controller. And so as we kind of modernize some of our systems, those records are exempt. Records of the Public Defense Commission related to representation. And so those, and the best way to think about those records is they're kind of already exempt as attorney-client privileged, but because they get submitted to the Defense Commission, we don't want to put them in a position where all of a sudden that exemption gets lifted because of where the records wind up for based on some of the responsibilities they have. I told you that public entities can now require more specific information. That's new Idaho Code 74-1024. A public agency may require specificity within the request, including the date range and a description to enable location with a reasonable effort. And so you as an agency, if as an entity, if you get a public records request, I don't know what this person or requester is looking for, you can go back to them and say, hey, can you be a little bit more specific? Is there a date range for these records that you're looking for? This envisions a more give and take within the requesting process. I think it's really important to understand that when on the government side, you're going back to the requester, you're allowed to ask questions related to what are you looking for, but under the law, you're not allowed to ask questions, why are you looking for it? And so always remember, if your question is more of a what question, it's probably okay. If it's a why are you looking question, that's off limits under the public records law. Idaho Code Section 74-109, the legislative exemptions have changed. And so personal communications between legislators, personal identifying information of citizens. And so if a citizen contacts a legislator and says, hey, I'm really concerned because X, Y, and Z are going wrong and my city doesn't seem to be doing anything about it, or my county or my mosquito district or whatever it is, that personal information is redactable on the part of the legislators. And that actually comes under, that actually naturally flows, if you're thinking big picture, from your constitutional right to petition for redress of grievances, right? That's a very...
Right. But the message itself remains public.
Right. The message itself is public. And then you heard me reference this earlier, right? 74-1064 G and H. Social Security numbers are exempt, and then redacted personal identification may be disclosed in a specific format. And so you can disclose just the birth year, just the last four of a financial number, a driver's license number, the last four of an employer ID number. And so the format for that would be that you have like stars in each of the slots for the number, and then just those final four numbers that go in there. If you get put in this, if you receive a request that contains this sort of information. And then we have a number of other exemptions. And I'm going to be honest with you, when you look at the public records law, there are, hundreds of exemptions in it. Since we are under a little bit of a time limit, and I don't know that anybody is ready for their afternoon nap, I'm not going to read all of the exemptions to you at this point, but I do want to highlight a few, right? The first is if it's an exemption that's provided elsewhere in state or federal laws. So if there's another provision of Idaho code that exempts the information, then it would be exempt. Same thing with federal law. And so, for example, a lot of the federal law for the FERPA, Federal Educational Right to Privacy Act, that is built into the Idaho public records law as an exemption. Law enforcement and investigatory records. These are records that have very specific exemptions. And under this provision, you have to go through them record by record. So it's not like I've got this law enforcement file, everything's exempt. It's this record is exempt because it would violate a person's right to, or jeopardize a person's right to a fair jury trial. And it has to be record by record. And if you're put in this position, as you go through these records, you may want to make sure that you annotate why each of these records is exempt from disclosure, because if you get challenged on it, you're going to need to put that in front of a judge to make that determination. Personnel records and records of professional discipline. What is a public record is salary. And so if you work for the government, your salary is a public record. Personal information from fish and game licenses, permits, and tags, residential street addresses and telephone numbers of law enforcement officers. Keep in mind, these are very specific exemptions, right? And so again, if you're looking at these exemptions and thinking, oh, they apply to a broad, giant category of records, you want to approach those scenarios with caution, because a lot of it is more specific types of information that may be contained within a record that other parts of are public. Trade secrets, production records, bids before they're open. One of the things I always like to offer to folks is that when you're getting into trade secrets and proprietary information, particularly on the government side, if you, for example, put out an RFP and somebody gives you proprietary or trade secret information, you may want to ask, as folks are providing that, hey, can you identify what that information is for us and maybe segregate it? And that way, when we get a public records request, we don't have to try to guess what your trade secret information is. And so that's one of those ways that you can kind of deal with those sorts of issues. archaeological records. And this actually, these exemptions came up in part because of some of these reality shows where folks go out and like dig up dinosaurs or whatnot. Well, folks are like, hey, that sounds fun. I want to try that out, and maybe I can find out where they are. Library records, licensing exams. And then, as I said, under 74-109, draft legislation and what the audit selection criteria are, those are confidential under the public records law. The one thing I will point out is that the draft legislation exemption is narrow and specific. It applies only to the Idaho legislature. So if you're, for example, a public entity that is not the Idaho legislature, the draft legislation exemption probably doesn't apply to you. And then it only applies while it's a draft piece of legislation. Once that legislation is printed, well, it's no longer exempt from disclosure.
Brian, the library records seem curious. What's the background on that?
So that's an interesting question. The library records exemption actually arose out of Supreme Court hearings. And what happened was, for those of you that remember this, when Judge Bork was nominated for the U.S. Supreme Court, folks were, going through his background, and they went out and discovered his video rental records. For those of you younger folks, we used to live in this era where there was this thing called Blockbuster, and we would go rent movies on big tapes called VHS tapes. It was a crazy time. But anyway, they got hold of his video rental records, and folks in Congress all of a sudden got kind of nervous, like, well, what if folks start inquiring into what we're checking out from the library and everything else? And so what happened was they brought a piece of federal legislation to prohibit, to make it so that library records of what you checked out were not public records. That legislation was blocked by the FBI and the NSA, the National Security Agency. And so the states looked at that and said, well, wait a minute, we don't want that information out there. And so state by state, they have adopted these provisions that protect your library records so that what you've checked out of the library is not a public record, and kind of recognizing, hey, there's some personal privacy that applies here. And so that's the genesis of that. So there are some access to exempt records that you as an individual hold. And so if the record is about you, you may have greater access to that record than the public, meaning the public can't come in and request the record. But since it's about you and you're the person that is subject to the record, you have the ability to make that request. You can make that request, you can inspect it. You even have an ability to challenge the content of that record in a process called a name clearing hearing. And so, for example, if like you're an employee and there's something in your file, you may be able to challenge that through a name clearing hearing. It's very specific. It doesn't come up very often, but I do know that some folks around the state have engaged in that in the past. In order to enforce your right under the public records law, it's a civil lawsuit by the person seeking the records to compel the agency to make those records available. And I want you to know that under the public records law, that's your sole remedy. So if you feel like you're getting run around, or the government isn't being responsive, or they're claiming exemptions that don't apply, or they're charging you too much for the records, whatever it is, the sole remedy is to go to court and challenge that decision. And the way that you do that is you go to the district court in the county where the records or some portion of the records are located. Then once you do that, the court schedules a hearing. It's supposed to be within 28 days that they order the government to show up and say, why haven't you disclosed those records? And then if the court reviews the documents in what's called an in-camera proceeding, meaning only the judge looks at the records, and then they compare the records with the exemptions that the government has claimed in each of those circumstances and says, yes, the government is right for claiming these exemptions, or no, the government is wrong for claiming these exemptions. understanding that that's the process. One of the things, if you're on the government side, that I cannot stress enough is that if you are in one of these actions, make sure you have the records subject to the exemptions with you or to the court or somehow. We've actually had a couple of scenarios around the state where folks have been in these public records fights. They've showed up to court and the court doesn't have the records that they're supposed to review. And the outcome is a very upset court for, I think, fairly obvious reasons. And so, kind of a practice tip for all of us that practice in this area, don't forget the records.
Hey, Brian,
Yeah.
I made a public records request to the mosquito abatement district and they wouldn't give me the records. And so then I called the office of the Attorney General and said that they should get me the records. And they just said, no, they just don't like me. They don't want to help me.
Well, Mr. Attorney General, it's not that we don't like you. It's not that we don't want to help. I mean, we want to help in all of those scenarios. The challenge is we don't have any authority to force anyone to hand over records. The best we can do is we can say, hey, we think you should hand over these records. But at the end of the day, they make their own decision. And under the law, the sole remedy is to take that agency or entity to court. That's the only way that you can get it done under the Idaho Public Records Law. And I think that, I understand that that sounds like a cumbersome process, right? That you've got to take somebody to court to get these records. And I think that there are some discussions that are occurring legislatively as to whether or not that's the best system. But for now, it's the system that we've got. And so it sounds cumbersome, but I also think that there's a little bit of, if you show up in court and you're successful, well, maybe that makes it a little bit easier for the next time you request the records or the next person that comes along. It shows that the system works. And yes, it sounds difficult.
Yeah, and I'd just like to say that the Idaho Press Club has successfully filed lawsuits under the Public Records Act twice in just the last couple of years and won both times. And none of that had to happen. None of that expense, none of that delay had to happen had the agency simply followed the law and turned over the records when they were requested. That's the easiest way for all of this to work. And I also had a question for you, Brian, about the 3 days. I think that some agencies tend to read that 3 days to respond as meaning they have to wait 3 days, but they don't have to wait 3 days, do they? In fact, the vast majority of the records requests that I file, they give me the records right away. They can do that, right?
Yeah, I think that's a good observation, right? Just because the law gives you 3 days doesn't mean it should take 3 days. I will share with you my personal approach on public records requests is when they come in, I want to get them complied with as quickly as possible because I know that those deadlines are out there. And I know that the public records law is kind of one of those statutes that I call it's a drop work statute. Meaning because of the deadlines that are associated with it, you have to kind of drop everything that you're working on to deal with the public records thing so that you don't run over the deadline. And so you kind of want to get it out as quickly as possible. On a practice note, for those of you on the government side, within our office, every public record request that we get has a very hot pink cover sheet that goes on it. So it says very clearly public records request. And the reason for that is because if you put it into any stack of papers, you're going to see that pink slip in there and know, hey, that is something that requires action and it has a very time-sensitive deadline to it. And so those are the sorts of things so that you don't inadvertently miss a deadline or inadvertently not comply with it. And I think that if you can turn them around, that's really good for you. The public records law does allow for you to require requests to be made in writing. But I think that, to me, that's, again, one of those customer service elements that you want to really think about. If somebody comes in and says, hey, can I get a copy of your minutes from last week's meeting? It may be a lot easier to just hand the minutes over or say, here's the website, have all the minutes you want, than say, hey, I need you to fill out this form and then we'll get back to you in 3 days. But I also understand that different agencies run their shops in different ways, and this isn't a criticism or anything else. It's just how you do it, how it fits within your agency is your own agency's decision. I offer up some tips for how to not get caught in missing deadlines or anything like that, or losing a public records request, which has happened in some spots before as well. Just small things to hopefully help folks comply with it. Under the law, there is a bad faith penalty. And so if you remember our earlier discussion that said all denials shall be in writing, if you don't provide that denial in writing, you're putting yourself into a scenario where it's very likely that you could be found in bad faith, right? Because you're just not complying with the very basic elements of what's required under the statute. There is an immunity provision. And so if you're trying to comply with the public records law and you accidentally provide exempt information, you're protected under the law. As long as you're in good faith trying to comply with the law and you accidentally disclose information, it's okay. And I can tell you that we've had some scenarios where we have disclosed information that was exempt. We have contacted the folks that we've disclosed it to, who've said, hey, we made a mistake. We'd appreciate it if you either redact it or return it to us, so we'll give you a redacted copy. 99% of the time, folks are very compliant with it. They understand it. And it's one of those things that as you're trying to comply, those things will happen from time to time. There's a prohibition on mailing lists. And so if somebody comes to you and says, hey, I want a copy of the names and addresses of all of your, I don't know, water bills or something, you can say to them, are you intending to use this as a mailing list? If they say no, you have to hand it to them under the public records law, unless some other exemption applies. If they say, yes, we're going to use it as a mailing list, well, under the law, you can say, you can't use it as a mailing list. We're not going to give you the records. It's a very thin prohibition because number one, all they have to do is say, no, I'm not going to use it. And then number two, it doesn't prohibit you from making your own mailing list. And so if I get a list of names and addresses and I line out 2 of those names and addresses, well, now I've arguably made my own mailing list. And so there's not a lot to that prohibition other than you get to make that ask. And that is a quick overview of the public records law and its ins and outs. As I said, there are a ton of exemptions within the law. And so there may be specific scenarios that apply, but for the sake of brevity and sanity within this presentation, we haven't gone through every single one of the exemptions.
Brian, first question from our audience on public records. Tony writes, I'm paraphrasing here. In regards to when the records request is officially received, does the 3 days start when the public entity receives the request or when the custodian actually gets the request? The context is, what if the custodian's out that week on vacation or out sick? What happens then?
So so the law doesn't say when that clock starts. I would interpret it as when it comes into the entity. Right. And so if you've got a custodian that you know is going to be out for a week, but you know you're going to get public records requests, you probably want to have some sort of coverage for that. Or, you may want to say, look, the person that complies with this is on vacation. Do you need this in a hurry? Or is it something that can wait for them to get back? Right. Communication. Remember, you're allowed to communicate with folks, but it's when the record gets received.
Yep. And Brian, I'm going to read some language here from 74103. It says that a public agency shall grant or deny a person's request within 3 working days of the date of the receipt of the request for examination or copying. That's the specific language.
Yeah. So that's the entity to me, right? As soon as it comes in.
So if the custodian is on vacation, they better designate a backup custodian.
Right.
That's the best thing to do.
Right.
Do I have to fill out as a requester, Brian, a form that an agency wants me to fill out in order to make a public records request?
Yes. Under the public records law, an agency can require requests to be in writing. The agencies, I know that some agencies have forms that they may want you to fill out. I know that you have the ability to make an email request for it. To me, it's, it's one of those things that if they want you to fill out the form, fill out the form. Otherwise, you can make it in writing, you can make it orally. But the agency does have the ability to say, this is how we want to receive public records requests.
Requesters will often specify that they would like the records request to be fulfilled in the form of electronic materials, PDFs, whatnot. Can a public agency choose instead to provide hard copies?
They're providing copies. So, I mean, it's assuming that they've provided copies, yes, that would comply with the public records law.
And I have to say, this has happened to me where I have received a stack of paper like that when it would have been much easier to get electronic. I think while that may be legal, it may not be the best approach. It would certainly save money for the taxpayers and time for everyone to do it in a faster and more efficient way.
Brian,
that's a customer service issue.
What I was going to say, customer service, and forgive me if you've kind of addressed it, all of this in that particular context, but if you haven't, as I've been looking at emails and comments and whatnot, talk about public records request responses as a customer service issue of good government.
What was that again, Scott?
The context, you often talk about the way we, as those in government, fulfill public records requests is good customer service. And if you touched on that, forgive me, I've been looking at emails and comments and whatnot while trying to listen as well.
Yeah, I mean, to me, when you think about the public records law and the open meeting law and, the fact that we're a representative republic, all of that to me indicates that government is like the ultimate customer service business, right? Our customers are the constituents that we serve as elected officials or public officials or even public employees, however you want to categorize those. And so I think that, to me, like anything else, right, you have a constituency that can, be very happy with the service that they're receiving from government, or they can become somewhat frustrated by it. And so when, for example, you have somebody that's like, hey, I would like a copy of the minutes from last week's meeting, and the answer is, oh, you have to fill out this form, right? Think about that from a customer service level. Are you increasing folks' confidence and satisfaction in government, or are you creating kind of this form over function frustration barrier with it? And I think that, depending on circumstances, right, the answer may not be the same in every one of those occasions, but it's something that we definitely want to kind of keep front of mind and think about as we put forth these sorts of things. As I said earlier, right, one of the things that I always think about is, are there steps that we in government can take to get out of what I call the request and response business? Meaning, is there a way that we know certain records are going to be requested, and therefore we're going to provide a platform and say, here's the public records that are most frequently requested, it's searchable, go have at it, whatever you want to pull out of there, go ahead. And is that something, is that a model that's worth taking a look at, right? A great example of that is with our state controller, Brandon Wolf. Right. He has created Transparent Idaho, which enables you to kind of look at, I don't know a better way to describe it, but it's kind of like the state's checkbook and expense report. And I mean, it's incredibly searchable to the point where you can go online and search all of the state agencies that have ordered pizza in the last year. That have been paid for out of public dollars. Like that's the sort of, but I think that, if we're thinking about it in terms of customer service and models, right, those are the things that maybe are worth having a discussion about.
Brian, you may want to comment about, an agency may have a record in a certain electronic format and someone asks for it be in a different format. Is the agency required to create a different record?
The first question is, if I, for example, have records in Excel and somebody wants me to provide them, I don't know, in QuickBooks or something. I'm not a financial software thing, so this is a horrible example because I don't know what I'm talking about. But if they want it provided in a different format, no. you don't have to convert that file. You can provide it to them in whatever the format is that you have access to. And then similarly, you don't have to create a record that doesn't exist. And so, for example, say someone came to our office and said, Brian, we would like a list of all of the employees in your office that are Catholic. Well, we don't have that record, right? I don't think there's nowhere that's ever been asked or anything else. And it wouldn't be like I jump on the phone and start calling everyone and saying, hey, what's your religion, right? We wouldn't have to create that record. And I think it's important because sometimes folks will make a request for a record that they think government should be keeping, but maybe for whatever reason, government doesn't keep that record. You don't have to then create the record. I think that also then takes us into yet another kind of natural question that comes from that. Sometimes people will make a public records request that's really just asking a question, right? And so they'll say, can I have all public records related to your position on X topic? And it's like, well, you're really just asking what my position is on X topic, and there are no records for that. And so you don't have to create records there. And it's a question. And it's up to you politically whether or not you want to answer it, right? The public records law just deals with documents in existence. It isn't, hey, you have to answer this question. Those are different things. And that question issue is more of a political thing. You know, for example, if Betsy asks us a question, right, there's a political calculus that goes into, yes, Betsy, we're going to answer that question, or you know what, we're not going to comment on it at this time, or we're not going to return your call, right? Those are all political calculated
bad idea
things.
Oh,
right.
Not return the call.
I'm not advocating for anything, but I think it's important that under the records law, right, all of those things come up from time to time.
On the format issue, Brian, sometimes an agency, particularly this happens with reporters who are interested in analyzing data, they will request information that includes data and expect to get it in, you know, an Excel spreadsheet or whatever. The data is kept in by the agency, but the agency will instead convert that into something static, like a PDF that can't be searched, that can't be analyzed. From a customer service standpoint, that seems like a really bad move to me. Is that appropriate to do?
So that's one of those areas where the public records law is silent, right? The public records law doesn't require that records be provided in like native format or anything. It just says you have to provide the records. And so it is a customer service question. I think it's something that's subject to negotiation. I do know that one of the elements of this is that under the public records law, we as public servants never absolve ourselves of the duty to protect the integrity of the public record. And so if, for example, we're providing a record in a format that can then be manipulated or changed, that we no longer have the integrity of that original document, that can be a question mark, right? And so that becomes part of the evaluation as well. And so, for example, you know, when we send out letters from our office, often they're in PDF format, right? Instead of Word format, where you just go in and be like, well, here's what the AG said. I mean, I think that that's a fairly obvious example, but it's the same thing with certain data points and whatnot. But I also know that a number of agencies are willing to engage in that discussion with folks as well. And so I think it's more customer service than public records.
Brian, can I put two more questions to you real quick before we wrap up? I've been improperly denied access to a record, but I cannot afford an attorney to file a lawsuit. What other options do I have?
So number one, you can go back to the agency and say, hey, are you sure? I think that these are, I don't think this is exempt. Number two, I'm going to give you three options. The first one is to try to keep negotiating with the public agency and say, hey, are you sure? I think that I don't see the exemption the way that you do, or you haven't identified an exemption, whatever the right answer is there. Number two, you could contact the state bar and see if there's a pro bono attorney willing to take this on. I don't know the likelihood of that, but it's an option. And then number three, you could contact the press and say, look, I made this request for a public record. It's being denied improperly. Is there anything that you can do to help out? And maybe there's a reporter out there that's like, hey, this is exactly the sort of thing that I've been looking to write about.
And a fourth thing, Brian, may be to narrow the breadth of the request too.
Right. Yeah.
Also may be able to accomplish it.
Right. If that applies. Betsy, what were you to say?
Sure. Well, I was just going to say that when an agency appears to be trying to hide something, that is not a good way of evading attention. That draws more attention, because when they're trying to hide something, we all wonder what it is.
And Brian, how long does a public agency have to keep a record?
How long what?
Does an agency have to keep a public record?
So that's a question of records retention. And I want you to know that records retention and the public records law are two separate laws, essentially. And under the public records law, the retention requirement is you can't start deleting or shredding records after you receive a public records request, right? We're not Enron. If you've gotten the public records request and you have it, you have to provide it. The records retention for the state are actually, I'm going to share my screen real fast because I want to show you all where this lives. You can actually find the public records retention schedule online. Let me see. I think this is it. And so you can find it online. Excuse me. Sorry, I've got this Zoom is not letting me get to the tab. There we go. Okay, so if you can see my screen, you'll see what I've got here is the Idaho State Historical Society webpage, and they've got state records retention schedules. And so you can go through this and you can see, if you look here, you've got state of Idaho general records retention schedule. So there's kind of an overarching schedule. And then you've got agency specific records. And if you scroll down, right, you see there's a number of agencies that have it. Then there's separate retention schedules for the State Board of Health and Welfare, as well as the State Board of Education. And so you've got this nice collection of records retention schedules that all kind of come together. And they're different sections of code. The section of code that deals with records retention and assigns the State Historical Society is Idaho Code Section 67-4126. And it's one of the powers and duties that's outlined for them. I think it's paragraph 5, but I don't know if I remembered that correctly or not, but it's in 4126. And so when you think about retention is a separately handled thing from the public records law. And I know that sometimes there's a little bit of confusion with regard to that.
That's a great resource to know that the Historical Society has those retention schedules posted.
Oh, yeah.
I realize that. That's great.
Yeah, that's why I wanted to make sure everybody knew where to find it and how to find it. The public records law is just the disclosure of the records. It's not the retention element. And so they're kind of in separate spots.
Whoops,
You're
Scott.
muted, Scott.
2 years, we gotta have this figured out. We've had a number of questions regarding where folks can find information from today's seminar. We're going to post Brian's PowerPoint presentations here in the newsroom. I will be creating in the next day or so a new announcement with all of the information, the video, Brian's 2 PowerPoint presentations, also links here. We've had some questions regarding where folks can find all of our manuals. Right here, the public records, open meeting, ethics in government, all of those are listed here in alphabetical order. So,
And when the full recording is available, we will also be posting a link to that on the IDOG website, which is openidaho.org.
that's all I've got, Brian. We're at 4 hours, or I'm sorry, 4:28, so 2.5 hours in.
We went a little bit over, but I sure appreciate everybody joining us. Lawrence, I think you get the final word.
Yeah, I'm going to wrap this up as quickly as I can. A couple of things. Brian mentioned that the government has an interest in maintaining the integrity of public records. You think about that, your property records, where your house is, where your farm is, where your business is, it's important that those records are maintained with integrity. As a young lawyer, I had an individual that I was prosecuting, and he'd been convicted of stealing a firearm. He stole a shotgun, transposed the number on the shotgun. It happened to be that he transposed it to an actual number of a different rifle. That was part of the evidence that he had stolen this shotgun. He then was convicted, and he posted an appeal bond, which allows him to not go to jail or to prison while his appeal is pending. So while he was out on appeal, on an appeal bond, I had two other cases against him. One of them was the theft of power, and he had some fantastical explanation of how I had acquired his fingerprints and placed them on the inside of his Idaho power meter cap. That didn't happen, but it was a really interesting story. I also had a case against him for inattentive driving. And as I was running through my files on my desk, I came across this case, and there was a motion to dismiss the case, and it had my signature on it. Now, quite interestingly, I'd never prepared such a motion, nor had I ever signed such a motion. Behind that was an order from the judge dismissing his inattentive driving case. And I talked to the judge, and the judge had never prepared, nor had I prepared, nor had the judge signed that order. Now, that was a curiosity. Just as an aside here, I make mention of the fact that if you're going to forge someone's signature, forging a judge's signature is not a good idea. They don't take kindly to it. So I went down to the clerk's office and I said, hey, what happened here? And the clerk said, well, this guy came in, it was his case, and we were really busy, so I just handed him the file. So he had inserted into the criminal file a forged motion and order dismissing his case. So I say that story to recognize that there is an incredible importance for the government to maintain the integrity of the records that they have. I then talk about another case, and that is, it was a criminal case as well, in which there was a criminal who was under investigation for some crimes against a number of public officers. On that occasion, he sent to us a public records request for the investigative records of the ongoing investigation on him. We denied his request, and he then took us to court claiming that he had authority to have the public records of the investigation disclosed to him. No, but he does at the end of the investigation, but not during the investigation. You just don't tell the bad guys what you're up to when you're trying to investigate crimes. One other quick story, and that is a long time ago, Senator Perry was the chairman of JFAC, co-chair of JFAC. And he called me on the phone and he said, hey, I've got this public records problem. Would you come to my office? And so I literally ran up the stairs to Senator Perry's office. And I walked in the door and I recognized the person sitting in the office. And he was a public records frequent flyer. He had made many public records. He also happened to be a little cantankerous. Not a little cantankerous, a lot cantankerous. And so I thought, oh no, well, this is going to be a tough conversation, and I'll try to help the best I can. And so as the story unfolded, I figured he'd made a public records request and wasn't getting a response. That isn't what happened. He had been elected to the Gopher District. Now, in southern Idaho, we understand what a Gopher District is. Gophers dig holes in the ditches and in the canals, and then they blow out the canals. So in those days, we would go out, and when I was a kid, we'd collect gophers, and then you'd take them to the Gopher District, and they'd pay you a nickel a tail. I think it's a quarter now or something. But that's how we used to, harvest gophers. So he was now the president, chairman or whatever of the Gopher District. And he had a neighbor who was a neighboring farmer who had made a public records request for the budget of the Gopher District. And I think it was like $5,000 or something. But he was bound and determined that he was not going to surrender the budget of the Gopher District because his farmer neighbor, was going to put that in the newspaper, and he was going to talk to everybody about the Gopher district budget. And he was bound and determined. And I tried to explain to him repeatedly that it's a public document subject to disclosure, and he had to disclose it. And he absolutely refused. So I left it there. I had done what I could do. And a few days later, he ultimately surrendered the super secret Gopher district budget. Those of us who serve the public, records that are public records subject to disclosure, disclose them. That's the best thing for us to do, and disclose them timely, and to treat the public saying, hey, there you go. They're the public's records. That's the whole point of what we are about. That isn't the only thing we do, but it is important that we give the public the opportunity to see the records of government. Want to mention very quickly open meetings. There's a specific enforcement procedure for the Attorney General. We enforce those responsibilities against state entities. We do not have authority to enforce them against local entities unless we're invited into a case by a county prosecuting attorney. But again, with open meetings, I have counseled and I have participated in open meetings many times. As Brian mentioned, and upon my question, have violated the open meeting law. Didn't do so intentionally. It was totally innocent on our part. I'd actually asked the question and make sure that the meeting was properly posted. The day after the meeting, I learned that it had not been properly posted. The meeting agenda had not been posted. Hey, that puts us in violation. So what do? We go back to the drawing board, renotice the meeting, held the meeting again, including all the motions, including all the votes. Why? Why do we do all of that? It's because it's the proper thing to do in terms of really and truly complying with the open meeting law. These are two critical statutes for us in government. It's also critical for the media, and it is critical for the public because they have a right to know. So I appreciate your joining us today, and I'm sorry that we ran long, but I think it's well worth your time, taking the time to listen and learn what it is we're trying to do with regard to public records and open meetings. Betsy, if you have something to say, please do.
I'd just like to say thanks, everybody, and hope this is helpful.
Thank all of you for attending. Thanks, Scott. Thanks, Brian. Appreciate it.
Bye-bye.